bilingual language. So class, we are doing the summary of the act and the exam oriented questions, right? So today we are going to do the LLP Act and Company Act. So first of all, let's understand the LLP. LLP is basically, it is the combination of Company plus Partnership Act. Okay, LLP is the combination of company and the provision of some Partnership Act. So now see what is written here in the paragraph. LLP is a body corporate with perpetual succession, existence of separate from the partners of the firm. That is called LLP, right? Any individual, it means these are the qualities of company: the body corporate, perpetual succession, separate from the partners, etc. Any individual or body corporate may be partner in a LLP provided that they are competent to contract. They are competent to contract. So we can say it is plus 18, sound mind, not disqualified by law. Every LLP have at least 2 designated partners who are individual, not corporate body. Only individuals can become the designated partner. So in LLP, the minimum number is 2, maximum is unlimited, and 2 designated partner, minimum 2 designated partners should be made in the LLP. So this is the basic quality of LLP. Every designated partner of a LLP shall obtain designated partner identification number, just like the director. Just like class, the director, because in the company we have read that in the company also the director need a director identification number. So same thing will be applied to the designated partner identification. The designated partner is responsible for all the doing of act, matter, things that is required to be done by the LLP. The LLP is incorporated once it is registered with the registrar. It means in LLP also registration is compulsory, just like the company. Okay, so LLP is incorporated once it is registered with registrar and gives a certificate that LLP is incorporated by the name specified. On registration, LLP may by its name capable of suing and being sued. It means once it's get registered, we can file the case and LLP can also file the case. So this is the basic, the quality of LLP, guys. That is important. Okay. Next, these are the summary. The mutual rights and duties of partner of LLP and the mutual rights and duties of LLP. So this is of partners and this is LLP, and its partner is governed by the LLP agreement. So this is very important that in LLP, the one of the most important document is LLP agreement. So the right and duties of LLP and the right and duties of partners are written in the LLP agreement. Is that okay? Because we have read in the partnership. In the partnership, the important thing is partnership deed. In company, the important document is MOA and AOA. Right? MOA and AOA. Okay? And in this one, we can say here, partnership agreement is there. LLP agreement is there. The rules regarding different conversion are provided in chapter 10 of section 55 to 58 of LLP, which has been dealt with in this unit beside the rules pertaining to maintenance of account. It means class, just like the company, the LLP also have to maintain the account, other records, etc. So basically, if I say that, it's contain the features of company. Okay? And ma'am and sir, if you are feeling any doubt, please ask the question. Okay? Please ask the question. Now, question. The advantages of which form of business organization is incorporated in LLP? It means in this one paid class we have done that partnership firm can convert into LLP, private company can be converted into company, and the unlisted public company can convert it into LLP. So just search in this option that where these words are written. Private company and public limited company, no. Sole proprietorship, we have not done. Partnership firm, we have done. Partnership firm and the private limited company, yes. C is the right answer because we have read this point. We have class read this point. Okay, next. True and false. LLP has perpetual succession just like company. Say yes or no. The answer is yes. Yes. Minimum number of designated partner is 5. Minimum. Minimum number of designated partner is 5. That is no. Minimum is 2. Under LLP Act, resident in India means person who has stayed in India for a period not less than 180 days during the immediate preceding year. 182. The answer is yes. An individual shall not become a designated partner in any LLP unless he has given his prior consent to such act. An individual shall not become a designated partner in LLP unless he has given his prior consent. The answer is yes, because the prior consent is required if any person is going to be designated partners. LLP may appoint a designated partner within 15 days of the vacancy arising for any reason. A LLP may appoint designated partners within 15 days of a vacancy arising for any reason. That is not the right answer. That is no. Okay, class? So these are the true and false, and every points we have already done. Every point we have already done in this session. Every point. Okay, it's over, class. So this is all about your LLP. This is, guys, all about your LLP. Now it's the time to study about the Company Act. It's the time to study about your Company Act. That is important. Okay, now see. First of all, the summary. Company is a artificial legal person which is created by law and can be dissolved by law alone. Right? It's an artificial legal person created by law, dissolved by the law alone. It is invisible, intangible, exists only in the eye of law. Yes, we know that. We know that the company have a distinct feature. A company can enter into contracts in its own name. Why? Because company have a separate legal existence. It can acquire, dispose property, can be fined under the provision of law for the violation of law. Exactly. Right? It is a distinct entity from the members forming it. Since a company is a distinct legal person, we know that it has a own signature, common seal with the name of company engraved in it. Consequently, it is also different from the partnership firm in the number of ways. Yes, we know that. We know that. Okay, so this is about your company. Now, class, we have read the various types of company, that is on the basis of incorporation, liability, on the basis of public interest, holding, subsidiary. So there are so many types of company that we have read. So many types of company, guys. Right? Now, the important document of company is Memorandum of Association and Article of Association. So these are the basic documents required by company prior to its incorporation has registered with the registrar of company. Yes. What is MOA? MOA give the basic details of company, its objective, and the most important document for a company. And what is AOA? that is the important document of company, consists of a set of rules and regulations, bylaws made by company for the internal management. So the basic work of the basic document, that's OA, talks about internal management, and MOA its objective of the company, and the basic detail is given in the memorandum of association. Is that okay? Both MOA and AOA normally filed with the registrar of company before registration of company. That is important. And once registered, the effect of registration is that MOA and AOA bind the company to absorb all the provision of memorandum and article. It means the company have to follow whatever the things that is written in memorandum and the article of association. That's it. Okay. Now, what is doctrine of ultravirus, constructive notice, and indoor management? Everything we have just read. So if we talk about the ultravirus, it's laid down company cannot carry on the object not permitted by its memorandum of association. It means company cannot go beyond the rules and regulations. What is constructive notice? Every outsider is assumed to have read the memorandum and article of association. Exactly. Suppose if we have given the documents, whether the outsider read or not, it's none of company business. If the company have given, it is a right of outsider to read all the things. Indoor management laid down that outsiders are not required to see the compliance of internal regulations of the company. It means if the company have changed anything, so it's a company duty to tell the outsider. So indoor management is basically protect the outsider. Protect the outsider, and constructive notice protect the company. That's it. Protect the company. Now about the member class. Member of a company has been defined in section 2 clause 25 of the Company Act. Any person competent to contract can become the member of a company. Exactly. There are various modes by which company can acquire membership of the company. Yes, we have read. Every company is required by statute to keep updated register of members, debenture holders, etc. The register are to be kept in the registered office and open to inspection by the general public. And we have seen the rights of company. Statutory rights, that is given in the Company Act. Documentary rights, the right which is given in MO and AOA. And property rights, that is the journal rights. That is the journal rights. Now, about some prospectus. What is prospectus? The public company has to issue prospectus. That is the simply brochure before raising fund from the public. The company, the promoters, directors of a company have certain liabilities for any wrongful statement that may be included in the prospectus on the basis of public invest funds into the company by the way of subscribing to the share and the debenture of the company. And suppose if any misstatement is done in the prospectus, so the civil and criminal liability will be imposed. The civil and criminal liability will be imposed. The management of the company is with the board of directors. That's it. And the company can have maximum number of 15 directors. However, a company may appoint more than 15 directors after passing the special resolution. That is important. That is important. Okay. Every listed public company shall have at least 1/3 total number of director as a independent director. As a independent director. The central government may prescribe minimum number of independent director in the case of the class of public company. So who will decide? The central government. Independent director that's not work under the control of any other person. The methodology to be adopted for the appointment of directors, rules of retirement of director is with the unit. Other provision of Company Act as regard holding of qualification share by directors, maximum number of directorship that is of 20. Party transactions, loan to director, etc. Everything is written in the Company Act. Okay, now let's start with the questions. True and false. Directors are the actual owner of the company. That is true and false. Directors are the actual owner of the company. That is true and false. That is false statement. Company has to be compulsory registered under the Company Act 2013. That is true. Just give me a quick reply. Company cannot enter into contract in its own name. That is absolutely false because company have a separate legal entity. So the company can enter into contract with its own name. Yes. If all the member of the company die, then the company will be wound up. That is absolutely no. The company will go as it is. Company is a legal person with perpetual succession. Every question you have to do. Okay, now in the case of company limited by share, the creditor of the company can recover money from the member if the company is not making profit. Tell me, class. A company limited by share, the creditor of the company can recover money from the member of the company, can recover the money from the member if the company is not making profit. Why, Baba? This is absolutely false. Why? Because we know now company and the member have a separate legal existence. So with the fault of company, we cannot ask things from the member. Member cannot transfer share in a public company without consent of other. This is absolutely false. Why we need a consent? Guys, why we need a consent? No need to take the consent. We can easily transfer of share to the any person. Prospectus is generally issued by public limited company. Prospectus is issued by the public limited company. The answer is yes. Now, the minimum number of members in a private company. So the minimum number of members, minimum in a private company is 2. Minimum in public company is 7. Maximum in the private company is 200. Very simple questions are there. Maximum number in a public company is n number. The private company, minimum paid up capital, and public company, minimum paid up capital. What will be the answer? Tell me, class. This is important one. The answer will be no minimum requirement. No minimum requirement. In a government company, the government hold at least dash percentage of paid up capital. That is 51%. So I think from today's session, this is sufficient. And rest of all, 1, 2, 3, 4, 5. 5 things we will do it tomorrow. Okay? 5 slide we will do it tomorrow. Okay? So that's all for today's class. So if you are new in this session, do not forget to take this video courses in which everything is written in a very detailed form, right? In the video courses, you will get, okay, you will get the recorded class of ABM, BFM, ABFM, BRBL. Okay, and you can just see this is also a one kind of paid class, but in the recorded form. Okay, so this is of English and this is of English medium. You can also take the CAIIB Prime Test Pack, ABM, BFM, ABFM, BRBL. That's contain 2000 question. So this is very important. And this is your bilingual. This is English medium paid class. And this is your CAIIB ka Mahapack. CAIIB ka Mahapack, if you just take it for 3 months, it contain the content, it contain the mock paper, doubt session, okay, the marathon that we have done, everything is there in the CAIIB ka Mahapack. Okay, so this is very important from the examination point of view. Done, guys? So that's all for today's class. Have a nice day. We are doing the questions and answer of your this one, Company Act. Okay, so I think we have done with the LLP, right? We have just done the summary of LLP. We have just done the questions of LLP also. And we also done the summary of the Company Act. Okay. And we have just done this question, this one, that's it. Okay. So now from next slide, we have to do this thing. Now, so you have to tell me the true and false of the following question. See, in the case of conflict between Memorandum of Association and Article of Association clause, the Article of Association will prevail. Say yes or no. So for this question, you have to know that what is Memorandum of Association and what is Article of Association. So if there's a conflict, because Memorandum of Association is one of the most important document of the company, and Article of Association is also, right? But this is more important than this one. So the Article of Association will prevail. This is absolutely the false statement, because memorandum is important. Memorandum, see, this is your Company Act, this is MOA, and this is AOA. So AOA is always subsidiary to the MOA, right, and the Company Act, always. Okay, and memorandum is subsidiary only to the Company Act. So this is important from the examination point of view. That's it. Okay, next. One of the clause contained in Memorandum of Association is known as object clause. So now let's understand the clauses of Memorandum of Association. Name clause, capital clause, liability clause, registered clause, registration clause, objective clause, and association clause. Association clause is also known as subscription clause. So that's why for B1, this is absolutely right. Right? The memorandum and article of company once registered, it's bind the firm. Tell me. Bind means that they have to do the things which is written in the memorandum and article of association. So memorandum and article of a company, one register, it's bind the firm. The answer is not firm, but it's bind the company. Bind the company. So this is wrong. Because firm, we know that in the partnership form, it may be registered or not registered. It is optional for the partnership firm to be registered and not registered. That's it. Okay, so this is the right answer. Done. Next. Doctrine of, see, 3 doctrines are there and the questions are there. Doctrine of ultravirus, right? Doctrine of constructive notice, and doctrine of indoor management. So what is written here in the first point, ultravirus lay down that every outsider is assumed to have read the memorandum of association and article of association. That is the right point. So first of all, remember the points. For this thing, you have to know what is doctrine of ultra vires, what is doctrine of constructive notice, and what is indoor management. That's it. So the doctrine of ultra vires, that is basically, it means beyond the power. Beyond the power. That is called ultra vires, right? So, but this sentence, that is every outsider is assumed to have read, this is known as constructive notice, because this is the definition of constructive notice, that whatever that is written in the ultra vires. So that's why this is absolutely false. This is absolutely false, because ultra vires means basically beyond the power. Suppose if the memorandum of association is there and the company go beyond the memorandum of association, beyond the memorandum, so that act will be ultra vires. So what is ultra vires? Beyond the power, and that act will be called as the void one. Okay, next. Doctrine of constructive notice. So I have already told you this is the definition of constructive notice. Now see what is written here. Outsiders are not required to see the compliance of internal management of the company. Class, this is the definition of indoor management, because constructive notice is this one. So this is also absolutely false. This is also absolutely false. Is that okay? Constructive notice, right? And this is indoor management. Then class, now what is indoor management? Lay down, company cannot carry out the object not permitted by its memorandum. Class, this is the definition of ultra vires. This is the definition of ultra vires. So that is absolutely false. All the statements are false. So now please read the statement. This sentence is of constructive notice, this is of indoor management, and this is of your ultra vires. That's it. I think this point is clear to all of you. Right, guys? This point is clear. Okay. Done. Next. Again, true and false. A minor can be the member of private company but not the public company. That is true and false. Tell me. A minor can be the member of this but not the public company. That is absolutely false. The minor can also become the member of public company. That's Japan. A member can inspect the register of member. That is the statutory right of member. So the answer is absolutely true. In a company limited by share, right? It is a type of company. The member is liable to pay the full nominal value of the share, and the liability of the member ends there. So please remember the types of company. Tell me, class. The company limited by share. This is the right definition because we have read company limited by share, company limited by guarantee, and unlimited company. So these are the three types of company that we have read. So under C1, the right answer will be, that is absolutely false. True, that is true. A company is required to keep its foreign register in India only. Tell me, guys. A company is required to keep its foreign register in India only. Tell me. So here answer is absolutely false. It have to be kept in the India, not only India. Okay, not only in India. Done. Now, there is no remedy available for the misstatement prospectus by the director. If suppose if any misstatement is there, so there is no remedy. And I think we have just read in the prospectus, if any misstatement is there, there is civil liability and there is criminal liability, right now. So no remedy available for misstatement of prospectus by director. That is a true statement. The answer is absolutely what? Answer is absolutely no. That is false. Because the liabilities are there. A company proposing to issue red herring prospectus shall file it with registrar at least 3 days prior to the opening of subscription list and the offer. Yes, B point. A company proposing to issue the red herring prospectus shall file it with the registrar at least 3 days prior to the opening of the subscription list and offer. That is true and false. That is absolutely true. So you have to remember this point. You have to remember. Okay, next. Fill in the blanks from the options given in the bracket, right? The maximum number of directors in a private company can be 3, 7, 12, 15. Tell me, guys. Maximum number of directors in a private company. Maximum, that is 15. Maximum number of directors in a public company class. In a public company, that is also 15. Minimum number of directors in a public company. Minimum. So the minimum is always that is public 3. And minimum in private company, that is 2. At least dash of the total number of directors of a public company are to be the person whose period of office is liable to determination by retirement or rotation. This is very important question. This is very important question. Tell me, guys. The question is very simple. At least how many of the total number of directors of a public company are to be the person whose period of office is liable to determination by retirement or rotation? That is 2/3. You have to remember. Every public company, private company which is subsidiary to public company having a paid up share capital of rupees dash must have managing an whole time director and manager. Tell me, class. Every public company, private company which is subsidiary of a public company having paid up share capital of rupees dash must have a managing and a whole time director or manager. So the paid up capital we have already done, that is absolutely nil. This is the right answer. Is that okay? Additional directors are appointed by dash, whether it is board of director, promoters, underwriter and the shareholder. So the additional directors are appointed by the board of directors. That's it. Alternate directors are appointed by, a very good questions. Additional director, alternate directors are appointed by which person? Directors, promoters, underwriters, shareholders. So here in this point, the board of director is the right answer. Okay, board of director. Now, the last one. Casual vacancies in the board of director is filled by the dash, board of directors, promoters, underwriters and the shareholders. What is the right answer? So this question also, that is a board of director. So this is all for today's class. So today we have done with the questions, right class? So these are the questions of your Company Act, and these questions we have already done this, right? So if you are new in this session, so this is your video course, right guys? So video course in basically, because you do not have a time to take the paid class, so that's why it's the time to please see the recorded session of the video courses, right? Second, whenever you will complete the recorded session, whatever questions I'm giving in the session, you have to do the questions. Next thing, after questions, you have to focus on the mock paper of the BRBL subject. And do not miss to see the YT session in which we have done the module wise questions, we have done the definitions, and we have done the summary and questions. So this is very important from the examination point of view. Very important. Okay. And this is your CAIIB, what is prime test pack. In the CAIIB prime test pack, suppose if your concept is totally clear, so you can join the CAIIB prime test pack in which ABM, BFM, ABFM, BRBL subject is there, which contained almost 2000 questions. Okay, this is totally based on the new syllabus and pattern. So whenever you just complete your concept, focus on the questions. That is important. That is important. Okay, questions are very important. And this is your live classes. In the live classes also, recorded sessions will be there, mock paper is there, right? Everything is there. And this is your CAIIB ka Mahapack. If you purchase it today, in the CAIIB ka Mahapack, it's almost contained. CAIIB ka Mahapack is basically of your, it's contain November-December session and May-June session of 2024, right? But if you just purchase the CAIIB pack of 3 months, because it is of 3 months, 6 months and 12 months. If you purchase it for 3 months, it will be very beneficial to you because it contains the paid classes, recorded session, okay, marathon that we have conducted in the June session, mock paper, ebooks, etc. So if you enroll in the CAIIB ka Mahapack, it will give you the benefit. Done guys? So if you want to purchase it, the process is very simple. Let me show you how to purchase the price. See, click on all courses, JV CAIIB, this is CAIIB November 2023. DV is going on, so click on this one. If you click on it for 3 months, click buy now, and the coupon code is exam 80. See, 80% discount is there. So this CAIIB ka Mahapack is very, very essential. Okay, it's also contain the recorded classes of your elective paper also. Okay, it's contain 10-hour plus marathon, mini marathon of per subject, and 10-hour plus marathon of the Maha marathon. Okay, so that is very important for all of you. Done guys? See, everything is there in this batch. So all of you, welcome to the Offices Adda 24/7, the special session of your BRBL subject in the English medium language. So as you know that we are doing the summary of the act and the exam oriented questions. So today we have to finish the module D. Only 2 acts are left, that is the IT Act and your Prevention of Corruption Act. Okay, so module D contain total 9 acts, and these 9 acts are very, very much important. Okay, now first of all, Information Technology Act 2000. What exactly this means? Okay, so the Information Technology Act 2000, that is basically, as we know that today we all are dependent upon the technology. Right now, we all are dependent upon the technology. So this Information Technology Act 2000, which was enacted consequent to the adoption of model law, and that is very important. It means from where this IT Act so it's referred from United Nations Commission on International Trade Law. That can become in the form of question. Okay guys, that can become in the form of question. That is United Nations Commission on International Trade Law. It's provide the legal infrastructure for e-commerce, right, in India, which evolve the use of alternative to the paper-based method of communication and the storage of information and facility electronically filing of documents of the government agencies, right? So this is your basic, about the IT Act. This section of the Act is very important in the electronic age where documents are transmitted, okay, through the electronic means to the everyone including the bankers. That is important. That is important, guys. Okay, so this is all about your Information Technology Act. Now let's do the question because that is only the summary part that is given in your IIBF book. Okay, guys, now the IT Act was introduced on the account of the initiative of, right now we have just done. The A option is IT Industry of India, Indian Parliament, Reserve Bank of India, none of the above, United Nations Commission on International Trade Law. What is the right answer? What is the right answer, class? You know that thing. You know that thing, guys. You know. So what is the right answer? So the right answer is United Nations Commission on International Trade Law because right now we have just discussed it. Right? So this is the main reference in which the IT Act was made in India. Next. Which one of the following is the appellant tribunal? Appellant tribunal under the IT Act. The Telecom Dispute Settlement Appellant Tribunal, Cyber Regulation Appellant Tribunal, Security Appellant Tribunal, and Information Technology Tribunal. Which one of the following is the right answer? Yes. Which one of the following is the Appellant Tribunal? What is Appellant Tribunal in which we can just do the appeal? Suppose this is your Debt Recovery Tribunal. If we are not satisfied with the decision of DRT, we can easily go to the DRAT, Debt Recovery Appellant Tribunal. So that is the appellant body. So in the IT Act, controller and adjudicating officer, that is the first authority that have to solve the matter. If we are not satisfied, we have to go to the appellant authority, appellant tribunal. So what is the name of appellant tribunal? We have already discussed this point. We have already discussed this point. So what is the right answer? What is the right answer? So guys, for the third one, the right answer is Telecom Dispute Settlement and Appellant Tribunal. For the second one, A is the right answer. Okay? A is the right answer. Next. Any person aggrieved by the order made by controller and adjudicating officer. C class, the first authority that have to give the order is controller or adjudicating officer. So if we are not satisfied, we can appeal to the Telecom Dispute Settlement Appellant Tribunal within how many days? Tell me, within how many days we can go from the date on which copy of the order made by the controller and adjudicating officer? 30, 60, 45, 10. What is the right answer? What is the right answer? Any person aggrieved by the order made by controller, adjudicating officer under the IT may prefer an appeal to the telecom dispute settlement within. That is so simple. Anyone? And if you feel any doubt in any question, you are most welcome to solve in the, you can most welcome to ask in the comment box. Okay, you can ask in the comment box. So for the third one, the right answer is 60 days. This is important. Now, so that's all for today's this one. Okay, guys, now the Prevention of Corruption Act. As we know that this act has been made in 1988. Why? Because in bank also the corruption is going on. It is amended in 2013, 18, 21, etc. Right? So the Prevention of Corruption Act was made in 1988 with the aim to combat the corruption and other misconduct mainly in the government and the public enterprise, including public sector bank. See, suppose if any corruption case come into picture, so the special judges are appointed by the government who will handle the case. Who? Special judge will appoint it, right? The minimum qualification of these judges are also stipulated. The statute also enumerate the maximum punishment and fine which may be prescribed for the different types of penalty, also prescribe the designation and the level of police officer who are authorized to investigate these. It means for the investigation, punishment, fine, qualification, everything is written in the paid class. That what is the qualification of these judges? I'm just telling you. The qualification is basically just like the session judge. Punishment minimum 3, maximum 7 year. And for investigation, for Delhi, for for Delhi, for other metropolitan areas and for other areas, there are different police officers that will investigate the matter. So that is important. Okay. The standard operating instruction have now been issued by the Government of India with a view to achieving the uniform and effective implementation for prior approval of the process of this one. Under the statute, power has been given to the investigation police officer above a specific level to inspect any banker's book also. It means class, if the corruption matter will be of your bank, so in that case, the police officer also have authority to investigate in the bank. Is that okay? That relate to the accounts of the person suspected to have committed that offense of any other person suspected to be holding money on the behalf of such person and obtain certified copy. And this is very important. High Court have empowered to consider the appeal and revision. So if a one word I will say, for appeal and for revision, High Court is there. Okay, class, for appeal and revision, High Court is there. That's it. Okay. Now, come to the question. The Prevention of Corruption Act require the offences should be tried by Supreme Court judges, District Court judges, special judges, or High Court judges. What will be the right answer? Okay, tell me. That is very simple. The Prevention of Corruption Act require offence to be tried by the special judge. So C is the right answer. What is the latest period by which a trial under Prevention of Corruption Act has to be concluded in all respect? 4 year, 2 year, 6 year, 3 year. What is the right answer? Maximum. Minimum is 2 year, 6 months, 6 month, up to 4 year. So the right answer will be latest period. 4 year is the right answer. Okay, 4 year is the right answer for this question. Done, guys? Next. Transfer of suit under the Prevention of Corruption Act may not at all be transferred from one court to another. That is true and false. If we talk about the transfer of suit, So the special judge can transfer the matter to the another special judge, but the special judge cannot transfer it to the High Court. No, that is not possible. So the question is, transfer of suit under Prevention of Corruption Act may not at all be transferred from one court to another. Okay, so that is false. We can transfer from the special judge to the another judge. Okay, now what is the maximum period of punishment which may be maximum or by imprisonment which may be meted out for the abatement of offense? What is abatement? To instigate. What is abatement? Instigation of offenses. So what is the right answer? That is very simple. The maximum period of the punishment is 7 years. This is the right answer. Fourth one, D is the right answer. Okay, now in metropolitan area notified by section 8 of the CRPC, no police officer of below the rank is authorized to investigate the offense under Prevention of Corruption, whether it is Inspector of Police, Deputy Inspector, Assistant Commissioner and Commissioner of Police. We are talking about the metropolitan areas, and metropolitan areas under Prevention of Corruption Act include Mumbai, Kolkata, Chennai, Ahmedabad, not Delhi, because Delhi, there is a separate provision of Delhi. Tell me, class, what is the right answer? What is the right answer? So for this question, class, the right answer will be Assistant Commissioner of Police. Fifth one, C is the right answer. Okay, C will be the right answer for this question. Done? So guys, that's all for today's class. So if you are new in this session, there is a video course available for you people. Video course is basically the recorded session. Video course is basically the recorded session which is available in this of all the subject. So if you want to enroll in this batch, so you have to see the recorded session that is available. Okay, otherwise after video courses you can also take the CAIIB Prime Test Pack, in which for all the compulsory subject the test paper is there, just like your exam paper. So if you want to enroll it, you have to simply use the code that is NOV80 for the 81% discount. That is very, very much important. And this is your live class. In the live class, the live classes are going on. Okay, in English medium, my classes is of 8 p.m. to 9 p.m. right? And if you are not able to see the live classes, you can see the recorded session. You can see the recorded session. Done? After that, the mock paper is also available in this live class. Then ebooks are available for to read this one. Okay, and you can ask any doubt session in this session, any doubt session, because doubt session is very, very much important for your exam clarification. Okay, so you can take this live class also. Okay, then this is your CAIIB ka Mahapack. So in the CAIIB ka Mahapack, if you will just purchase now, so normally its validity is 1 year. But if you purchase this today, so it will give you 2-year validity. It will give you 2-year validity. And in this Mahapack, if I will show you, it contains all paid classes. It contain all paid classes, right? It will cover November December session plus May June session of 2024. Done. Mock paper will be available. Ebooks are available in this CAIIB ka Mahapack. Then doubt session you can ask at any time. Doubt session is there. After that, you can easily see in the CAIIB ka Mahapack, that is your this one marathon that we have conducted in the June session. So the marathon is there, right? Then the video courses of the elective paper. The video courses of the elective paper is also there in the CAIIB ka Mahapack. So there are so many things that is given in the CAIIB ka Mahapack. Okay, so you can just purchase it. And now if you want to purchase, the process is very simple, because right now the discount is going on. Right now the discount is going on. See, click on just write down Adda 24/7, click on all courses, JIB, CAIIB, and this is your CAIIB November 2020. This is the live classes and this is the Mahapack. So see, apply the coupon code, that is now 80. See, 80% discount is there of the CAIIB ka Mahapack. Recorded videos, interactive classes, okay, and see, test series are there, ebooks are there, everything. And specially it includes all the 5 elective paper, that is a ruler, HRM, IT, digital banking, risk management, and central banking. Done. And this Mahapack is now bigger and better. Why? Because it's contained the 10-hour marathon. You can see. Okay. It's contained the 10-hour of marathon, as you can easily see that. See, 10-hour marathon. Done. 5-hour Maha marathon. Practice paper, and every second and fourth Saturday the doubt session is there. Okay, every second and fourth Saturday the doubt session is also there. So this is your Mahapack. And if you want to enroll in the CAIIB video courses, so the video courses are all, this is the test series. Okay, for the test series you have to use the coupon code, that is now 15. For the test series you have to use the coupon code, that is now 15. And for the video courses, now 80. Navratri, because Navratri is going on, now 80. You can also take the separate video course also. Okay, separate video course also, and the ebooks are also available. For everything, coupon code is already given here. So for this is for ebooks, now 15. For video courses, now 80. For the prime test pack, it is now 50. And for the live classes, that is now 80. And see the CAIIB, this one. And you can also take the bank promotion Mahapack. So the bank promotion Mahapack is also very much important. Okay, so that's all for today's class. Hello everyone, very good morning to all of you. Welcome to the Officers Adda 24/7, the special session of your BRBL subject in the English medium language. I hope so my voice is audible to all of you, okay, right? Now, so guys, today we have to discuss the act of module C, because I think we have done the module D, in which we have done 9 acts, its summary and its question. So now we have to move forward to the module C, and module C contain 10 acts. So now let's do the, first of all, Bankers Book Evidence Act, that is of Okay, Bankers Book Evidence Act. This act is basically talks about the what kind of evidence the bank can present before the court. What I have said, what kind of documents or what kind of certified copy the bank have to present before the court. Suppose if the matter of the bank is in the area of court, because we know that before this Lok Adalat, Consumer Forum, Ombudsman, the dispute of the bank always go toward the court. So the bank is not a special entity that the court will basically see the matter of bank. So that's why, guys, as we can see that the Bankers Book Evidence Act define the main terms pertaining to the statute and have been converted in the unit when the books, what is given here? When the books of bank are produced in a printout form, it is to be accompanied by certificate detailed in section 2 clause A. We do not have to remember the section. Similarly, any record of the bank required by the court has to be accompanied by certificates and brought out in the statute. When data is stored in computer form, certificate from person in charge of the computer system is required. This is very important. When data is stored in computer form, this one, certificate from person in charge of the computer system is required. So this is important. This is, guys, important from the examination point of view. This one. Is that okay? Done? Now, next one. So basically, class, the crux of this act is very simple. If I just talk about the crux of the act. So see, before only court were there who will give justice if any dispute of the bank will come. And after that, we have so many Lok Adalat, Consumer Protection Act, we have a Consumer Forum, and we have a Ombudsman. So there are various alternative dispute resolution system in which the bank's complaint can be easily solved by these authorities. Okay, so that's cool. Now, if any proceeding where bank is not a party, it means what it means. Suppose if the dispute is between X and Y and bank is not a party and certified copy are produced, bank's officer cannot call as a witness. It means if bank is not a party, class, so always remember we cannot force bank officer to be called as a witness, okay, as copy is admissible evidence, because certified copy is itself the admissible evidence. Always remember that this original copy, the bank do not have to show the original copy. Bank only have to show what? This certified copy, because certified copy should be signed by the proper authority. Then it will be called as the authenticate document. Okay. The court can order inspection. The court can order inspection of the books of account. The order for inspection of book must give 3 clear days. This is very important. That can become in the form of question. It means, suppose if the court have to give order, so that order must given in the 3 clear days. And 3 clear days include 3 working days. Exclude public holiday and Sunday. Court has discretion to award cost for any application under this. So it is the power of the discretion power of the court. Okay. Clear days, court can order, and bank is not a bank. These are the important documents. Please see this terms. Whatever the things that I have highlighted, that can be also come in the form of question. That is very important. That is very, very much important. Is that okay, guys? Is that okay? Any doubt? Okay, now let's do the question. Number 1 question. As per the Bankers Book evidence, what do you mean by the term judge? Tell me, guys. What do you mean by the term judge? Judge of district court, the first class magistrate, judge of Supreme Court, judge of High Court? Yes, class, tell me. Yes, class, tell me. Yes, what will be the right answer? The right answer will be judge of the High Court. This is the right answer. Okay, you have to remember. Okay. Which of the following persons are not authorized to issue certificate under Section 2A of the Bankers Book Evidence Act 1891? Whether it is manager, principal accountant, person in charge of computer system, and none of the above. Which of the following is the right answer? Tell me. Which of the following is the right answer? That is so simple. See, suppose we know that original copy, we do not have to present, right? Only the certified copy we have to present. What is this? Certified copy. The certified copy should be signed either by the manager or principal accountant. Plus means the person in charge of the computer system is also required to sign here. So that's why none of the above will be the right answer. None of the above will be the right answer for this question. Is that okay? Then guys, this is the right answer. A court might order banks to prepare and produce the copy of entry that is relevant to the matter in issue, accompanied by the certificate that no other entries are to be found in the book, and such order has to be served. How many clear days? 3, 5, 4, 7. This thing we have done in the summary. This thing, guys, we have done in the summary. So what will be the right answer? Yes, class. So we have already done 3 working days. Okay. Any order made under Act for the payment of cost or by the bank may be enforced as if the bank were party to the proceeding. It means if bank were the party, then only the court can give order. Say yes or no. What will be the right answer, guys? Tell me. So the answer is absolutely. Okay. If the bank is the party, then only the court can give order. Okay. That's it. Now we have to focus on the Legal Service Authority Act. Okay. As we know that you people give us banking services, right? We people give us teaching services. Same thing, the legal service include organize the Lok Adalat also, because Lok Adalat is that organization in which you can say the matter can be easily solved by the retired or serving judge. The Lok Adalat do not have to follow the procedure just like the normal court. Okay, guys? So in the Legal Service Authority Act, we can see that Lok Adalat are organized by this act.
This is very, very much important. Okay, it is organized under the Legal Service Authority Act 1987. Important. That can become in the form of question because many students just tick mark on the Lok Adalat Act. No, the Lok Adalat is given under this act. Lok Adalat are organized in the area and usually consist of the serving and retired officer and other person. That can be also come in the form of question. That who sit here. Specified by the state authority, district authority, right? This is 1, this is 2. The Supreme Court Legal Service Committee, 3. The High Court Legal Service Committee, 4. And the Taluk Legal Service Committee, this is. So that organize the Lok Adalat. So this is very important. Who organize? 2 authority, 3 committee have power, right? Lok Adalats come under this act. And who usually consist of retired and serving judge plus other person. That's it. So please see the paragraph. This is important. This is important, guys. Is that okay? Lok Adalat are intended to bring about compromise and settlement. What is the basic aim of Lok Adalat? Compromise the matter, settlement the matter. That is a basic theme of Lok Adalat. Done? Next. Lok Adalat derive jurisdiction by the consent of the party. It means, class, if both party were agree that the matter should be go to the Lok Adalat, then the matter can become. Second point, when one party file application to the court by one of the party to the dispute, then, okay. Third point, the court satisfied that the dispute between party could be held settled by the Lok Adalat. It means there are 3 ways that is written. Consent of the party, when one party file application, and prima facie court satisfied that yes, this matter can be solved by Lok Adalat. And the third point is, if the court satisfied that the dispute between can be solved by the Lok Adalat. So these are the way in which Lok Adalat can cognizance the matter. Is that okay? Now, in respect of a potential dispute, any party may request the authority committee. It means this is the 4th way. Suppose if we request to the authority and committee organizing Lok Adalat to refer the dispute for determination. That is important. That is important, guys. That is important. Lok Adalat shall be guided by the principle of justice, equity, fair play, and other legal principles. That is important. Each and every points are important from the examination point of view. That's why it is called summary class. That's why it is called summary. Okay, class? Done. In the case of settlement, award means the justice which is given by Lok Adalat shall be binding on the party and no appeal shall lie. This is important. Each and every point is important. The justice which is given by this is called what? Award, and no appeal shall lie. Okay? Now, if no settlement, the case shall be remitted back to the court. This is very important. Suppose if the compromise and settlement is not done by the Lok Adalat, so the case shall be remitted back to the court, which refers the matter to the Lok Adalat. In the case of potential court case, if the matter is not settled, the Lok Adalat shall advise party to seek remedy in the court. So we have an option that we can file a fresh case in the court. Okay. Every Lok Adalat has power to specify its own procedure. They can make their own procedure for the determination of any dispute coming before in addition to power. Presently, the monetary ceiling of amount for settlement through Lok Adalat is 20. Means up to 20 lakh, the Lok Adalat can solve the matter. Okay. The main advantage of bank and financial institution is that usually the Lok Adalat settle their NPA, non-performing asset, by the compromise method. That is important. That is, guys, important. Is that okay? Done? Let's do the question. Lok Adalat is organized under the Lok Adalat Act. Yes or no? Tell me, class. That is important. So here, Lok Adalat organized under. Why? Because Lok Adalat organized under Legal Service Authority Act 1987. Lok Adalat are organized to settle only the existing dispute between the parties, not the future parties. Yes, class. Not the future parties. Tell me, not the future parties. The answer is absolutely false. If one party intends to refer dispute to Lok Adalat, the consent of other party is not required. That is a good question. So here, if one party intends to refer the dispute to Lok Adalat, the consent of other is required. Not required, that is false. The consent of other party is also required. Lok Adalat shall strive at arriving at compromise or settlement between the party. Lok Adalat shall strive at arriving a compromise and settlement between the party. That is yes. There shall be no appeal against award of Lok Adalat. We cannot file the appeal. That is absolutely true. We cannot file the appeal. So that's all for today's class. So I hope so you people are regularly seeing this session. Okay. So this CAIIB video course is available for you people. So if you want to enroll in this CAIIB batch, so you have to use the code that is October 77 for the 78% discount. In this video course, you will get everything. You will get everything in a systematic manner. Everything. Right? This is your prime test pack. For the prime test pack, same coupon code in this. For each compulsory subject, the paper is there. This is your live batch. Okay. So right now, if you people have a don't time to see the recorded session now, so please focus on the, you can also see the this live batch which is going on. Okay. And it is better if you focus on the CAIIB ka Mahapack, because what are the benefit of CAIIB ka Mahapack? I will tell you. First of all, Adda 24/7, all courses, JIB, CAIIB. This is CAIIB November 2023. If you see this Mahapack, so Mahapack is basically of 3 month, 6 month and 12 month. If you click on 3 month, so you will get the CAIIB ka Mahapack for 3 month, right? This is your highlights. You can see here. It includes, first of all, this CAIIB ka Mahapack include the live batches, revision batch that we will launch, third, mock paper, ebooks, recorded session of the elective subject, which is very important. Okay, see, elective subject. So suppose if you select it for HRM, you can please focus on the video courses of HRM. And before exam, we will launch the live batch of elective paper. So you can easily join if you purchase the CAIIB ka Mahapack. Okay, and you will also get 10-hour plus marathon, mini marathon, plus Maha marathon, practice paper, and second and fourth Saturday, there will be the doubt session. So guys, if you want to enroll, you can please Apply the coupon code, that is October 77. Click on this. Apply the coupon code, that is October 77. Apply 77% discount in the CAIIB ka Mahapack. This one. Okay, so this is all for today's class. If you want to crack this exam, please follow for the concept, follow one paid batch. In every paid batch, teacher is giving you the questions. Please solve the question. And third, believe in yourself. Do not forget to do the mock paper, which is very important for your analysis, for the self-analysis. And always stay tuned with the YouTube session, because YouTube sessions are also very much important from the examination point of view. So that's all for today's class. Have a nice day. Hello everyone, a very good morning to all of you. Welcome to the Officers Adda channel of Adda 24/7. So we are doing the summary of the act and the important questions of that act. For the whole content of your BRBL book, the paid class is there. In the paid class, whatever the content I'm giving in you in the PPT, that is sufficient for your examination point of view. Okay, now let's move toward the summary and exam oriented question. So guys, we have already done module D, right? We have already done module D, and right now module C is going on. Right now module C is going on, so that's why this is very important from the examination point of view. Okay, now so today's act is basically Integrated Ombudsman Scheme 2021. So what exactly this scheme means? See, first of all, we have to understand what is Ombudsman. We have to understand what is Ombudsman. So Ombudsman is that authority who have authorized to listen the complaint of the customer. That is a work of Ombudsman. We know that we have a court, we can go to the court for the justice, but for the particular purpose, the Ombudsman is basically, there to just listen the complaint. Okay, so in our act, we have to study what? Reserve Bank Integrated Ombudsman Scheme 2021. So this is the integrated. What is integrated? 3 acts has been merged and it is converted into the 1 act. It means now we do not have to study the 3 acts regarding the Ombudsman. See, what are the 3 acts? The first is Banking Ombudsman, NBFC Ombudsman, Digital Transaction Ombudsman. So 3 separate Ombudsman Act was there, but these 3 has been removed. Now the complaint regarding bank, the complaint regarding NBFC, and the complaint regarding digital transaction, all these things come in the hand of this act. So this is the basic purpose of the act. This is the basic purpose of the act. Is that okay? Integrated Ombudsman Scheme 2021. Done, guys? So it coverage most bank, financial institution and system participant. Beside providing definition of the term most often used in the scheme at various places, the scheme deal with the location of office of the Ombudsman appointed under the scheme, their power and the customer grievances, dispute they would be required to take cognizance and resolve of the satisfaction of the party. Okay, that's cool. Next. The scheme also speak about the setting of centralized receipt processing center. This is very important. This is very important, guys. What is this? CRPC. The short name is CRPC. So what exactly the CRPC is? That is so simple. The short name is CRPC. So this is the processing center in which, suppose if any complaint will go, so that CRPC will initiate the complaint. That CRPC will initiate the complaint. Okay. For processing of customer complaint relevant to the scheme and the staffing of the office of the ombudsman, and the CRPC will responsibility and the cost of RBI. It means RBI have a power to organize CRPC, and the whatever cost that is spent on CRPC, that will given by the RBI. That is important. The scheme also has provision for party to the dispute appealing against the decision given by ombudsman subject to the certain condition. Okay, suppose Nikita ma'am is complainant. She filed the complaint to ombudsman, appellant authority. There should be appellant authority also regarding this one. Okay, so if we are not satisfied with the decision of ombudsman, so we have a right to go to the appellant authority. That's it. The scheme allow RBI through an order to suspend for such period as may be specified in the order and the operation of all or any of the clauses of the scheme, either generally or in relation to the any specified regulated entity. And what is regulated entity? Bank, NBFC, system participant. That's it. So these are the regulated entity. Okay. Under the scheme, who is appellant authority? Tell me. The first option is Governor of RBI, second is Finance Minister, third is Deputy Governor, fourth is Executive Director of RBI. Tell me, who is appellant authority? Who is appellant authority? Who is appellant authority? So the right answer, appellant authority, that is an executive director. D is the right answer. Okay. What is the maximum period for which ombudsman, deputy ombudsman may appointed under the scheme? It means what is the tenure of ombudsman and deputy ombudsman? Tell me. Tenure. What is the tenure? So the tenure is basically 3 years. B is the right answer. All complaints may be sent under scheme to the CRPC only. Tell me. All complaints may be sent under the scheme to the CRPC only. Tell me. Right and wrong. So the correct answer is not only CRPC, but we can also suppose if somebody complaint given to the RBI, so RBI can also send it to the CRPC. So that is not only. If only is not written, then you can tick mark on the right answer. If complaint made by a customer to a regulated entity is not replied, what is the minimum period after it received by RE? May the customer make a complaint to the ombudsman? That is important. That is important, guys. Tell me. That is important. What is the right answer? The right answer for this one is basically 1 month. Okay, next. An ombudsman would be sent copy of complaint received from the customer of regulated entity to the regulated entity. Suppose if Nikita ma'am have filed a complaint against regulated entity to the ombudsman, so the ombudsman will give the copy of that complaint to the regulated entity or not? Tell me. Those candidates who are just seeing this session in the recorded form, please note down this session. That is true. That is true, guys. Okay. So these are the 5 questions for this one. Okay. Now let's start with the Consumer Protection Act. I think we have finished this act. Okay. So Consumer Protection Act is basically made in 1986. But in 2019, we know that various technology come into picture. So with the technology also, we just purchase the goods and services. So if any defect will come, we can file the case. So the Consumer Protection Act is nothing but it is basically, who is consumer? So consumer is a person. See, who is consumer? Because see, I have already told you the definition of consumer. I have already told you, okay, in the definition terms. So consumer is basically one who consume goods and avail the services. That is called consumer. If a person have purchased the goods and avail the services for the resale and for the commercial purpose, that person cannot be act as a consumer. This is very important definition. So the Consumer Protection Act, as you can easily see that 9th August 2019, this amended act come into picture, right? While certain provision of act like establishing the, in 2019, the Central Consumer Protection Authority come into picture. This authority was not there in 1986 Act, okay? Section 2 define the various definition terms that we have already discussed in the definition terms. The unit also deals with the establishment of what? Central Consumer Protection Council, State Consumer Protection Council, and District Consumer Protection Council, which are advisory council. What are they? They are the advisory council, mainly to render advice on the promotion and protection. It means what are the rights of these council? The rights is very simple. You can see promotion and protection of consumer rights under this act. This is the right answer. Okay, this is the right answer. Done, class? Now, the Central Consumer Protection Authority, this is the authority. The main work of this is to protect, promote, enforce the right of consumer, okay? Prevent violation of consumer rights under this act, inquire and cause an inquiry or investigation to be made in the violation of consumer rights or unfair trade practices, file complaint before District Commission, State Commission and National Commission, and review the matter relating to and factor inhibiting the enjoyment of consumer right. So these are the, you can say, important one. These are the main functions of CCPA, that is a consumer, Central Consumer Protection Authority. That is very important. That is very, very much important, guys. Is that okay? Done? This is important. Let me make a diagram. A very important one, okay? This is 1986 one, 2019, 2021. We are just talking about the jurisdiction. We are just talking about the jurisdiction, okay? So we know that we have a three authority. 1, 2, 3. Okay, we have a 3 authority. So this is your District Commission. This is your State Commission. and this is your National Commission. National Commission. So there are 3 commissions. So what is the limitation we have to understand? The limitation is basically up to 20 lakh, up to 20 lakh, right? Under state, 20 lakh to 1 CR, and this is above 1 CR. This is of 1986 one. Okay? 2019 up to 1 CR, 1 CR to 10 CR. This is above 10 CR. 2021, this is up to 50 lakh. This is 50 lakh to 2 crore, and this is above 2 crore. So this is your limitation that you have to understand. 20 lakh to 1 crore. This is 1 crore. You have to at least remember these 2 years. That is very important. This is very, very much important. Please revise the jurisdiction. If any goods and services is of below 1 crore, suppose of 50 lakh, so under 2019, that will directly go to the State Commission. So this is your jurisdiction. This is your jurisdiction. And one thing I just want to highlight you. What? See, District Commission to State Commission, that is within 45 days. State Commission to National Commission, 30 days. And National Commission to Supreme Court, that is 30 days. So this is the appeal days class. This is the what? Appeal days. That is important. District to state, state to national, national to Supreme Court. And if Nikita ma'am wants to file the case, so Nikita ma'am her 2 year of limitation. Nikita ma'am have a limitation period of 2 year. 2 year limitation if I want to file the case to the District Commission. If I want to file the case directly to the State Commission, 2 year limitation. National Commission, 2 year limitation. Limitation means under 2 year I have to file the case, otherwise my right to filing the case will be dissolved. That is very important. Okay, now let's do the question. Which one is the following is not complainant class? Tell me, which is not the complainant under the provision of this? Any voluntary consumer association registered under this act, mediator, central authority, legal heir and legal representative. Who? Tell me. Complainant means the person who filed the complaint. It means the person who filed the complaint. So under this question, the right answer will be mediator, because mediator is the authority who will solve the dispute. Okay. Consumer include person who buy goods services for the commercial purpose. I have told you the definition. I have told you the definition, guys. So a consumer include person who buy goods services for commercial purpose. That is false. Which one of the following is the chairperson of Central Consumer Protection Council? Tell me. Which one of the following is the chairperson of Central Consumer Protection Council? Prime Minister, President, Finance Minister, Minister in charge of the Department of Consumer Affairs. What? If that question can become in the form of question, because in this question that is asking who is the chairperson of Central Consumer Protection Council. So it may be possible the chairperson of State Council, the chairperson of District Council can also be asked. So please do not forget to remember. So for this, the right answer is D is the right answer. Okay, D will be the right answer. So that's all for today's class. So we have finished 2 Act, Integrated Ombudsman Scheme 2021 and the Consumer Protection Act. So I think all 2 acts finish. So this is your CAIIB video course, because right now we are doing the summary of your BRBL book and the questions. So if you want to take the content, this is your content, CAIIB. This is your content. Is that okay? So in the content, please focus on the recorded session. Please focus on the recorded session. That is important. Recorded session. Okay. This is CAIIB Prime Test Pack. Each compulsory subject have a mock paper. So now, if you have just done with your paid class, questions of mine, then it's a time to do the mock paper. Okay, and this is your CAIIB ka, this is the live classes which is going on, and this is your CAIIB ka Mahapack. In the CAIIB ka Mahapack, everything is given, plus marathon that we have conducted in the June session of each act, that is also given. Okay, so do not forget to take this CAIIB ka Mahapack also by using the coupon code, that is October 77. That's it. Okay.